What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to go through some of the issues that popped up this morning, the fact that court was canceled, how often something like that happens, how we deal with it if lawyers get sick, if judges get sick, if clients get sick, if witnesses get sick. I know you guys had a lot of questions, so we'll walk through all of that. And we're going to take a look at some of the most recent filings by the Commonwealth and some responses by the defense because it lets us know some of the strategy as to what the lawyers want to get into going forward on this case. And we'll see if we can figure out, because so many of the arguments happened at sidebar, maybe happened at a motion hearing that happened today reportedly. And we're going to try to figure out what the answers to some of these questions are, because if the determinations are made at sidebar, we don't get to hear them publicly on the record, but they are very important as to how each side wants to try this case. So make sure you guys hit the like button. Let's get to it. So I'm on a little mini, vacation, staycation, whatever you want to say, up in Tallahassee. Went to the golf tournament today. It was awesome. Had a lot of fun there. And so no court today was kind of interesting. I was like, oh, okay. So I was planning on just having my AirPods in, walking the course. I'm going to do that tomorrow morning because I'm going to watch a little bit of the golf tournament before I head back home. Because we got some family stuff coming up, birthdays, stuff like that. And so with no court, I was getting so many questions. What do you think happened? Even in our lawyer group chat with me, Kelsey, and John. And I was like, somebody's probably sick. Or a witness, if it's an expert witness that something happened to them, they missed their flight, they got double booked, something happened to them where they couldn't show up, that might be a reason to cancel court potentially or push it. If it was just a normal witness or a lay witness or a law enforcement witness, the judge would probably force Hank Brennan to just put somebody else on the stand. But we've heard reports he's getting closer to the end. So if he's getting closer to the end and it's the accident reconstructionist or something like that, and they're unavailable for some reason, I could see why we might have to cancel court for the day if it was something like that. But all reports are Karen Read is sick. That's what the reports are saying. Okay. So I haven't necessarily heard that confirmed, but going with that, we'll talk about how that's going to affect the case, right? Because is Karen Read have the type of sickness that caused her to just miss today? Usually, if you have a sore throat or a cough or something like that, you still show up to court. Is it COVID? Is it something contagious? Is it a fever? What exactly is happening with that? And I know you guys have a lot of questions, so I'm going to talk about a couple things, let you get some questions in, and then we will talk more about it. But I wanted to talk about some of the things that were reported this morning. Judge Cannoni is holding a Zoom hearing for Karen Read. Prosecutors are in the courtroom. Attorneys Yannetti and Jackson apparently are remote. The judge wants this at sidebar. I'm the only reporter in the courtroom. Let me see if there's anything else. The judge has decided to close the courtroom, and I was asked to leave, probably due to the issues with Read's defense team hearing what was said at sidebar. Hearing has been going on for 10 minutes now. Jackson originally appeared off camera as he's dressed in a hoodie. Judge said she didn't care and turned on his laptop. Hearing over, no comment from Brennan. Hearing has been going on for 10 minutes. Okay, we already got that. Due to HIPAA, they can't say who's sick or what it might be. Court confirms the reason it was not held is a health issue with someone involved in the case. Okay. And then we're going to go now to Christina Rex. And I'm just showing you what kind of I've been seeing out there. You guys can let me know what you've been seeing. Christina Rex, 2 sources confirmed to WBZ that Karen Read is sick, which is the unavoidable circumstance that canceled court today. We have not received a scheduling update on the rest of the week. Okay. So that is the basic unavoidable circumstances that Karen Read may be sick. Okay. So, and some questions are already coming in, right? They still had a hearing. It sounds like it did. It doesn't mean they necessarily decided anything in the hearing. It could have been a motion hearing. It could have been a scheduling hearing. Yes, Jackson, they took kind of a long break. I think it was yesterday to discuss something with scheduling. SST, what happens if Karen Read is sick for many days? If she's, vomiting or something like that's really, really bad, where she has a fever, needs to go to the hospital, get an IV, she's, getting dehydrated, whatever it may be. Or if it's, Kelsey, somebody said it's cutting in and out. So let me know if there's a sound issue. Let me know if there's a sound issue. Um, if she really is that sick for many days, you have to take off many days. She is an indispensable party. You cannot go forward without her. Okay. And that's really, really important to understand. So when we get into what could cause multiple delays or a longer delay, that's one of them. If she is really incredibly sick, I'll tell you some stories about some things have happened in my trials dealing with sickness and whatnot. I got really sick, even had a fever. This was pre-COVID though, with my dad in a federal case that was a multi-week trial. Sore throat, lost my voice, fever, was popping Tylenol, Dayquil, was just crushing Dayquil, and I just kept going. We didn't take any days off. I didn't miss court. I showed up, and just kept rolling, and that's just kind of how it was. We have had a situation during COVID where somebody got COVID. We had to break. We had to continue the trial. We had a situation where COVID, where defense counsel was going to get his COVID shot in the middle of trial. We took that day off. So it was a 1 week trial. We ended up getting ahead of schedule after the first day. So when we took a day off, it was fine. We were able to finish it in 4 days. So that obviously is something that we could schedule in the trial, which sometimes happens. We had a juror get sick. We excused that juror because we had enough alternates where it wasn't going to be in jeopardy for us not to be able to try the case. We had a judge get sick right before trial that caused us to continue the trial. We've also had a judge get sick where we had a senior judge step in and try the case. I don't think that necessarily is what happened here, just because of how difficult this case might be. But there's all sorts of reasons that can come in that, I posted on Twitter. It's life, right? This is our job. This is, Karen Reed's life. But when you do something for 6 to 8 weeks straight, life is going to happen. There's going to be emergencies, family emergencies, sickness, surgeries, something very important for one of your kids. And a lot of times that can continue trials to get continued, but it can also cause just delays in the trial that's already scheduled and already moving. And that's something that can absolutely happen in a case like this. All right. Let me see if there's any other questions about that. So glad you came on today. Hit that like button. Yes, everybody, please hit that like button. We are about to go through a couple of the motions that a bunch of you had questions on. I tried to answer them kind of quickly yesterday during the live, but I wasn't able to really dig into some of the issues that came up and some of the motions that were filed. And hey, we got blessed with a day off, so we can take some time to dig into that. Love your insight. Do you think Bev is overly interfering in the case? She seems very biased to me. I don't think she's overly interfering in the case. I have absolutely disagreed with some of her decisions. And just so you know, every time I disagree with a major decision, I will talk about it on stream. Every time I agree with the major decision she's made, which has happened as well, I will talk about it on stream. I will tell you why I think she did it. I've found some that make her seem like she is very biased, some that make her seem like I think she just made the dead wrong decision, and some that make her seem like she didn't want to make a certain decision, but she did. So I'll usually let you know exactly what I think of some big rulings that she has here on stream. The nefarious Jen McCabe. Peter, I've wondered how hard it is to learn the terminology in law school. Most lay people didn't understand legalese, so it's hard. Is it hard to learn? It's a great question. It's like a kid that grows up speaking 2 languages. Like, I had a bunch of friends that spoke Greek and English or Spanish and English, and it was really easy for them to learn and speak both. I wouldn't say it's overly difficult, especially the hardest part in law school is learning how to think differently when you read and break down how words are used in a sentence with commas and this big part of the sentence and the lesser part of the sentence, and when you use certain describing words and when you put ands or ors or shalls or musts or mays or might. How important that is, and just how you look at every single word. That was probably harder than learning any specific legalese. I'm in Massachusetts. That's why at we are Karen Reed. I'm in Mass, so that's why at we are Karen Reed. I'm not sure what that means. Sam, yay, I finally caught you live. Thank you, Peter. Welcome, Sam. LL Brief. I want to understand why the judge is sustaining so many state objections and overruling defense objections. The state objections seem poorly made. So we're going to talk about that when we get to the motions. The defense is definitely pushing the envelope, and the judge has made certain decisions pre-trial that she's not going to allow the defense to get into certain things. So when they try to get into those things, or they ask questions that are getting into those things, those objections are going to be sustained. Additionally, the defense is asking certain questions or saying certain things as fact that they want the jury to hear as a fact that has not necessarily been testified to, that would get objected to and sustained in a lot of trials. So there are definitely some things that they're saying that are objectionable. And like I said, there have been some horrible swings and misses by the judge on some of the rulings that she's made, but I don't think it's like a every objection occurrence, personally. Do you think Lally secretly wants a not guilty verdict? No, but if that is what happens, I will tell you, my man's probably going to be walking around with his chest out a little bit higher because he's like, I convinced 8 jurors she was guilty and big shot Hank Brennan couldn't do it. Wouldn't surprise me. It could be her Crohn's. Could be. Can they have court without her? Not unless she allows it and waives her appearance, which I highly, highly, highly doubt. I would never advise a client to do that. So I don't think that that's what is going to happen. Monica, doesn't Karen have lupus? I'm not sure. I know she does have medical issues. Charlotte brought up she has a lot of legit medical issues. Yeah, it could happen. It didn't seem to pop up during the first trial, but you know, it's very legitimate if that happens with a criminal defendant. They have a constitutional right to be there. They should be allowed to be there. I don't think any judge would ever. It's impossible for a judge to say it doesn't matter. We're going to continue on without her. Karen Reed has both Crohn's and multiple sclerosis. I don't know how much the first, but my mom had MS. If she did have a flare up, she's going to be a jelly mess flopping around and will definitely be out. Yeah, I don't really want to speculate personally what it is or what's going on. The reports are it is Karen Reed that is sick, and if she is sick, they deserve to take the day off. Karen has colitis and MS. She may be having a flare up of colitis and may be unable to be away. Okay. Can she be there in a Zoom? Not usually, and she's not able to. She is, as everybody has pointed out, she's very involved in cross-examination, talking about the witnesses, passing notes to the lawyers. She should be able to do that. You have a right to be involved in your defense. She is very involved in hers. Nothing is going to take the place of her sitting right there next to her lawyers. What's the most interesting new evidence this trial? I mean, I think the Higgins video is pretty big to me. The Higgins video is pretty big as far as new evidence that we've seen so far. You guys let me know in the chat what you think. Purely LA. Will Brian Higgins need to testify now that his prior trial testimony was shown to be incorrect? Thanks for all you do. He doesn't have to testify if neither side calls him. Will either side call him is the big question. Will they call him? Will they find it necessary? Okay, let's get to, thank you, Rebecca, for gifting 10 memberships. And we're going to get to the first motion here. And it is the Commonwealth's motion to preclude inadmissible hearsay under the guise of a Bowdoin defense. So Bowdoin defense is the police investigation sucked. Obviously, they have a right to present that. And they have been presenting that. But the Commonwealth is going to argue they're getting into things that are irrelevant to a Bowdoin defense, but using this Bowdoin defense to get into it. And a lot of it happened with Yuri Buchanan. But it's not over now that Yuri Buchanan's done, because any officer that is called to the stand is going to have these same issues, even if the defense calls an officer or even a former officer who has since been terminated, right? Wink, wink. So these are going to be issues we're going to see in the future of this trial as well. Evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated in circumstances in which it was reasonable to suspect that the police should have conducted such tests, followed such procedures, or investigated such information is admissible. So basically, he's setting out what the definition of this Bowdoin defense and what the defense should be able to get into with the witnesses that are on the stand. However, a defendant does not have an unfettered right to elicit evidence regarding the adequacy of the police investigation. The admissibility of such evidence hinges first and foremost on its relevance. There was a case they cited that the judge properly exercised discretion to exclude third-party culprit evidence as part of a Bowdoin defense, where the defense counsel's proffer did not demonstrate what the probative weight of the Bowdoin evidence exceeded the risk of unfair prejudice. So Brennan is setting up what he's going to ask for the judge to limit or to exclude completely. While Bowdoin preserves a defendant's right to attack the adequacy of the police investigation, that attack is still constrained by the rules of evidence. Nothing in the Bowdoin case authorizes the defendant to introduce otherwise inadmissible hearsay. The defense's attempt to elicit inadmissible hearsay under the guise of a Bowdoin defense is improper. The defense has failed to establish that certain information, particularly confidential materials provided by the United States Attorney's Office in February of 24, were known to Sergeant Yuri Buchanan, or that in these circumstances, it would have been reasonable for police to investigate such information. So it says Yuri Buchanan, but if they call any other officer, Tully, Proctor, Lank, anybody else that the defense tries to do similar things to, it's going to be a same objection. And Hank Brennan, I would agree with part of this, that if the feds gathered information, turned over information, worked on something, and the officer on the stand has no clue about it, then he shouldn't be able to testify about it. But the defense should be allowed to ask, do you know about this? Do you have this information? Right? Because if you remember back, Hank Brennan was objecting to things like, did you review this in Proctor's termination notice or whatever it was? And he would say no, which just seems wild. So I think Hank Brennan is asking for something broad, mentioning something specific in hopes to win a motion like this. And we're going to read the defense's response to this as well, because what they're calling inadmissible hearsay, is it actually hearsay, number one? And if it is hearsay, is it actually inadmissible? Because the defense has some good points that they make in their response. Let's read footnote 1. Sergeant Buchanan was not party to the federal protective order nor confidential materials. Further, he was sequestered during the first trial. Sure, I don't think anybody would disagree with that. For example, the federal government's decision to obtain cell phone records of an investigator and civilians does not fall within the parameters of Bowdoin. I don't remember them saying, did the federal government take this, right? Especially when there has never been a showing that those cell phone records were material and relevant to the investigation. Footnote again. The defense previously filed Massachusetts Rule Criminal Procedure 17 motions for access to Brian Higgins, Brian Albert, Kevin Albert, Kenneth Berkowitz, and Michael Proctor's cell phone records, which were denied due to lack of relevance or materiality. So he puts that in the footnote. He can't possibly be talking about Higgins's text messages, right? Because he also referenced and asked about Higgins's text messages, especially Higgins's text messages with John O'Keefe, and how there was no motive for Higgins to end John O'Keefe's life. So he can't be talking about that, right? Under Bowdoin, it must be reasonable to expect that police should have followed certain procedures or investigated such information to be admissible, which, again, is another point where the defense doesn't have to say, the feds did X, Y, and Z, to say, you should have done X, Y, and Z based on what you knew at the time. The questions repeatedly proffered by defense are an improper attempt to admit otherwise inadmissible evidence. Evidence admitted pursuant to a Bowdoin defense is not hearsay because it is not offered to show the truth of the matter asserted. Rather, that the information was provided to police is information that the testifying witness has personal knowledge of, and yet that information was not adequately investigated. I would say 90+% of what the defense asked to Yuri Buchanan fell within that parameter. And I would even include, do you know about this? Do you have personal knowledge as you sit here today about this, about X, about Y, about Z? That's all fair game to me. Now, there were some questions that they asked Yuri Buchanan that he shouldn't have known, wouldn't have known, were objected to, and were sustained. And that's how trial is supposed to go. A motion like this, to me, is not really something a judge should make a big ruling on. The judge should say, it's going to be a question-by-question, case-by-case basis. I will make my determination within my discretion when a question is asked and an objection is lodged. That's how it should go. Evidence admitted pursuant to a Bowdoin defense is not hearsay because it is not offered to show the truth of the matter asserted. I agree. Rather, that the information was provided to police is information that the testifying witness has personal knowledge of, and yet that information was not adequately investigated. Such evidence that police failed to investigate leads concerning another suspect must have been known to law enforcement at the time. And sometimes I think the defense and maybe some of the public would disagree with what the witness is saying they knew or didn't know at the time, right? So that could be one of the issues we're running into as well. Bowdoin does not permit the defendant to ask questions without proper foundation or questions that are replete of unauthenticated, inadmissible hearsay solely to infect the jury with speculative claims that the defense has continually failed to establish. certain things about fist fights or, whatever, some of those types of questions potentially that Buchanan would probably not know. The defense is insinuating that is maybe inferring something to the jury. The more wide-ranging the defendant's attacks on the police investigation, the broader the Commonwealth's response may be. Sure, I don't think the defense is going to be scared of the Commonwealth having a robust cross or redirect or rebuttal or whatever it may be. Similarly, if the defense intends to claim that police lost or destroyed evidence, the defense bears the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the evidence would have produced evidence favorable to his or her cause. So here's what I'll say. Do I think the defense can prove beyond a reasonable doubt that law enforcement either buried, planted, affected, manipulated, destroyed, edited any evidence in the case to include witness statements, tail lights, video evidence, the car itself, any of that stuff, right? Do I think the defense can prove that beyond a reasonable doubt? No, I don't. I don't think they ever will be able to because of the investigation or lack thereof at the time. But do they have a reasonable possibility based on concrete evidence to say that? My opinion, yes. Number one, we've had multiple witnesses say the police report is wrong. What they said my statement is wrong. Absolutely wrong. It's different. We have no taillight pieces confirmed by Yuri Buchanan found until after they had the vehicle secured. We have no pictures of the taillight prior to it going into the Sally Port. While it was at, he didn't take out his phone. He didn't take any pictures. How? Why? That's crazy. Does it mean they planted it? No. Does it mean they destroyed it? No. But it does all add up to being a reasonable belief and a reasonable possibility. Was Proctor by that taillight? Yes. Did they try to doctor the video? Maybe not. Was the video not a fair and accurate representation of what they were saying it was? Yes. Was there a better angle that would have shown all that? That skips for 40 minutes right when they show up? Yes. There is more in this case to lead to a reasonable possibility of some shady stuff going on to where the defense should be able to argue it. Will the jury buy it? Will the jury believe it? I don't know. I don't know if they will. They don't have to. There's video of the taillight. Fine. And the prosecution is putting that on. I'm just telling you how most cases go, and it is not like this. They have more in this case to present a reasonable possibility that something is going on, something shady is going on, that they have an absolute, in my opinion, legal right to present that to the jury. It doesn't mean she's not guilty. It doesn't mean they're going to win. It doesn't mean that the jury's going to believe it. I'm not saying that. And by the way, they have expert testimony that says that taillight didn't cause those injuries to his arm. So then how did the taillight get broken like that? It's something that absolutely should be presented. Okay? My opinion. I'm not saying that anybody has to agree with what actually happened, just that there is think about it, a reasonable possibility, not beyond a reasonable doubt, not by the greater weight of the evidence, like barely, not even probable cause, probably a reasonable possibility. How many times in trial have we heard one side or the other say, not a mere possible doubt or anything is possible? Well, that's how low the bar is for this. Okay. It is a reasonable possibility. Am I yelling? Sorry. Siobhan said, who is Peter yelling at? Sorry. I may be yelling. One of my other videos, like my phone was on my channel and it like started playing in my pocket. It was like a butt play, I guess you can call it. And I was like, why am I screaming? So I've got to just keep it chill. Keep it chill. Okay. If the defendant meets that burden, the trial judge must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant, discussing loss of potentially exculpatory evidence within the context of a Bowdoin defense. Given the defense strategy to ask repeated, improper, and argumentative questions, a curative instruction is insufficient. Therefore, the Commonwealth requests a voir dire hearing of Sergeant Buchanan for the court to determine whether the areas of the defendant's proffer of Bowdoin evidence is admissible before evidence and argument is made to the jury. So if you remember, they did do this a little bit with some of the connections between the Proctors and the Alberts, and the judge did not allow the defense to get into that. That doesn't seem like what he was asking for here. So I don't know what her decision is going to be on this. It seemed like they still were able to get into quite a lot, not just on the rest of cross, but even in recross. And so when it comes to that, I think this was probably granted in part, sustained in part, or overruled in part, and that she is going to handle it on kind of a case-by-case basis. Let's answer a few questions before we read the defense's response. Thanks, Peter. Hola, good day. From Melbourne, Australia. 5:30 a.m. I don't follow Karen Reed, but here anyway. So controversial, eh? Love and healing to all. Pin King. Can you have the allegations against the Buffalo School District that was made in the unsubscribe process by angry cops? And SVU detective Richard High. I'll have to look into it. If the prosecutor doesn't call Proctor and the defense does, can the prosecutor ask leading questions on cross? Is that a strategy? Yes. Yes, they would be able to ask leading questions. There are scenarios where both lawyers might end up asking leading questions. Ashley Adams. Watching your videos over the years inspired me to enroll at USF for criminology. What are some criminology careers tied into law? You're great. Thank you, Ashley. I mean, there's all sorts of like investigators, criminologists, people that put stats together about crime in different areas, about injuries in different areas, about different streets and roads that are more dangerous, or neighborhoods or cities or certain areas near certain businesses that the statistics can really help with a lot of cases. I'm not sure what specifically is connected to criminologists, but those are some criminologists I know personally that do that type of work or that studied criminology. I heard that they had a Zoom meeting today. Yes, they did. Oh, and by the way, I heard some people saying that this is kangaroo court, that they're allowing some of the lawyers to show up in person versus some in Zoom. You should never allow that. If one lawyer is going to show up in person, they all should. My personal experience, that's all baloney. We've done that multiple times. We've shown up at Zoom when counsel from out of the state doesn't, and vice versa. We've showed up in person. And when counsel's outside the state, they show up by Zoom, and we don't care. That's fine. We've all shown up by Zoom. We've all shown up in person, or we've shown up by Zoom and somebody else has shown up in person. It doesn't matter for a lot of hearings. You wouldn't want it for a trial or something very serious or some evidentiary hearing. But I don't see any problem with that. Frankly, it's a courtesy if Jackson's back in LA, right? I don't know if he is. I'm just saying like that sometimes can be a great courtesy. So I wouldn't say there's anything nefarious with that if they are having some of the lawyers show up in person and others by Zoom. Hi, Peter, watching from the UK. Thanks for streaming, even though court canceled. Can I ask you, taken part in any trials that have been televised or streamed where we can watch a genius at work? I don't know if I'd say a genius at work. No. We've had like some interviews after trials that are on like old Bay News 9 and some of the Tampa local stations. We've done some interviews post-trial before on some cases, but not that I'm aware of that any trials have been streamed. Maybe in the future, we'll see. Thought I'd share. So proud of my niece who is graduating from Boston University this weekend. That's awesome. With 2 bachelor degrees. She's moving right on to law school, loving another lawyer in the family. Proud aunt. Congratulations. That's awesome. Is Brian Higgins more sus than the Mavs getting the number 1? Yeah, that was just so weird. I don't know if it's suspect. I guess it could be the NBA trying to balance this stuff out. Anybody doesn't know, the Mavericks, after trading away Luka in a historically horrible trade, got the number 1 pick, going to get Cooper Flagg, who's supposedly a generational player. It does seem a little sus. I don't know. It's Crohn's disease. Belinda, if Karen is sick, it's not surprising. She has been under tremendous pressure for 3 years. As someone with her medical conditions, this trial is a joke. She's obviously innocent, and the judge is shameful. I will say, yeah, a lot of stress, a lot of pressure. People's body reacts sometimes. Hi, Peter and lawyer fam. Who do you think the Commonwealth will call in their remaining case in chief? What would be the lawyer strategy? They have to call the accident reconstructionist. They have to call some kind of medical expert. I know they're holding the dog bite expert for rebuttal. I would think there's still going to be more law enforcement witnesses. I've heard they're going to call John's niece and nephew. And we may get an indication of some more witnesses that they might be calling in one of the motions coming up. Amy Lively, my mother had Crohn's and it was debilitating during stress. I feel for her. From your perspective, how do you feel when court is canceled? Does it affect the flow, invoke sympathy from the jury? So usually I don't mind it if it's just, one day. I would hate it if there was a week, but you can catch up on some other work. You can prep for what's coming. You can respond to some motions. You can file some motions. I don't hate a day in the middle of trial. Like when I think one of my longest trials is either 5 or 6 weeks, something like that. And every Friday we took off. It was federal court. So every Friday we took off, and that was actually really nice. Let's just hope that the judge is paying attention when she rules on these questions by question objections. Early in an investigation, how much contact is there with the district attorney, i.e., could the direction to plant evidence come from there? Sure, it could. It depends on the jurisdiction, but a lot of times the prosecutor can be involved, especially if it's a high profile or a cop death like this. They could absolutely be involved from the jump. Thank you, Amy, for gifting 10 Lawyer You Know memberships. And let's get to the next motion here. We're going to get to the defendant's response. Pull it up. Thanks, Susan, for gifting some Lawyer You Know memberships. Defendant's opposition to the Commonwealth's motion to preclude. So the motion we just read, this is the defendant's response to that. Now comes the defendant and responds to the motion. The Commonwealth seeks to undermine Ms. Reed's right to confront her accusers and to cross-examine witnesses, a right conferred by both the Sixth Amendment of the United States Constitution and Article 12 of the Massachusetts Declaration of Rights. They give the right practical effect, allowing questions on cross-examination on any matters relevant to any issue in the case, including credibility and matters not elicited during direct examination. The only requirement is that questions are asked on a reasonable and good faith basis, regardless of whether the party intends to offer substantive evidence of the statements at trial. And we've said that before, right? Where some of the questions the defense asked were like, listen, they have a reasonable belief it's true. They have a reasonable belief it's relevant. They're going to ask it. They think it's going to prove something in the case. It may get sustained. The judge may say, this witness doesn't have knowledge of that. It's outside their scope, whatever it may be. As long as the defense has a good faith basis for what they're asking, they can't say something like, isn't it true Brian Higgins saw aliens come from outer space and do this to John O'Keefe, right? There's no reasonable basis for that. But especially when they have, a lot of times we don't have stuff like concrete evidence in the case where it's like, oh, Brian Higgins texting Karen Reed, gets ghosted, texts John O'Keefe, motions to him at the waterfall, goes to Ken PD right after and moves stuff around. Like that's concrete evidence. Stuff is happening right in the relevant time period. So from my perspective, it really is more than you have in most cases, especially for a reasonable and good faith basis. Questions do not need to be based on admissible evidence, thought, though they may be curtailed when a witness makes continual and repeated denials. Other limits on scope of cross-examination are harassment, prejudice, confusion of the issues, the witness's safety, or interrogation that is repetitive or only marginally relevant. Vague suggestions of racial, ethnic, or religious prejudices without any support are impermissible. Limits, however, do not include instances where the defense seeks to elicit testimony from a witness about the adequacy of police investigation. Such testimony is explicitly protected under Bowdoin as both relevant and permissible. Testimony elicited in support of Ms. Reed's Bowdoin defense does not have the effect of harassing the witness or confusing the jury, nor are the questions marginally relevant. Rather, questions on cross-examination about an investigator's knowledge of the very investigation he was conducting is highly relevant. And one of the things I noticed when I read the Commonwealth versus this is this motion seemed to be more specific to this case. The Commonwealth was talking about vague stuff with the federal investigation that maybe I missed it, but I didn't notice the defense hammering away at federal investigation stuff that Yuri Buchanan was not aware of. All right. The testimony Ms. Reed seeks to elicit in support of Bowdoin defense is inherently not hearsay and is admissible. Defendants have a right to base their defense on the failure of police to adequately investigate a murder in order to raise the issue of reasonable doubt as to the defendant's guilt in the minds of the jury. Specifically, Ms. Reed is permitted to offer evidence regarding a third-party culprit whose existence was known to police, but whose potential involvement was never investigated, a la the combination of Bowdoin and third-party culprit. And something else the judge has to consider, the judge already allowed them to go over and to elicit testimony on the Bowdoin defense and allowed them at least to have a limited third-party culprit defense. So because the judge has already made those decisions, that's how it should start. That's really how it should start, that it's allowed to come in unless they do something that crosses the line to make it prejudicial or harassing, or they continue to ask things that are irrelevant, which I don't think we've gotten there personally. All right, let's keep reading. In this scenario, the risk of prejudice to the Commonwealth is less because the police are able to explain what they did to determine that the subject was not guilty of the crime, which is exactly, by the way, what's happening with Brian Higgins. The defense is bringing up X, Y, and Z. Look at how suspect Brian Higgins is. And the Commonwealth is coming back saying, did you find a motive? Was he here? Was he there? Was he doing this? Was he doing that? That to me is exactly how this is supposed to go. The defense brings something up, and the Commonwealth absolutely has the right to respond and explain why that's BS and that person's not guilty. And they either investigated them enough to determine that they're not guilty or didn't feel it was necessary to even investigate them. And eventually the jury determines who they agree with. Do we agree there's nothing there you didn't have to investigate? Or should you have and you didn't? And we find that to be a reasonable doubt. Whether there are other potential suspects with incentive to direct police attention away from themselves and towards someone else, namely the defendant, is highly relevant to a criminal trial. Another court found it improper to prevent a defendant from cross-examining police officers about their knowledge of the criminal records of other potential suspects. Evidence offered in support of a Bowdoin defense is not hearsay testimony. It is not offered for its truth. And it seems like the Commonwealth agrees with that based on their own motion, right? And then they cite some other cases. Because any statements introduced as a part of such a defense are offered not for the truth, but to prove that the police did not take reasonable steps to investigate, those statements are not hearsay. The Commonwealth's assertion that the evidence properly was excluded because it constituted inadmissible totem pole hearsay misses the mark. The defendant did not offer the substance of the informant's tips for the truth of the matter asserted. So, let me give you an example. Somebody comes up and says, I saw Brian Higgins swing on John O'Keefe in the parking lot of the waterfall. By the way, I'm not even going to use this case. I'm going to use a completely separate example. Luke Clanton is like the #1 amateur player in the world, plays for Florida State, got to watch him play today. It was awesome. Let's say somebody says, I saw Luke Clanton smashing the window of the #2 player in the world in the parking lot. And it's like, okay, the police end up arresting somebody else who's a notorious criminal for smashing the car, stealing something in it. And the defendant's like, well, why didn't you even investigate Luke Clanton? It's like, well, we didn't think it was Luke Clanton. It's like, well, somebody said it was Luke Clanton. That doesn't mean it's true that the person that the informant said it was Luke Clanton doesn't mean it was Luke Clanton. What it means is it told you there's an eyewitness who said it was Luke Clanton, so you as the investigator should have investigated Luke Clanton. And that's the point. And then you as the investigation, what you should say is, yes, we did investigate. It turns out Luke Clanton was winning another golf tournament while all this was taking place. We have security footage that shows the time the window was smashed, Luke Clanton was teeing off on hole 6, right? That's what you should be able to say as an investigator, that you looked into the tip and you proved it wasn't true and you proved it wasn't that third party. So the tip isn't coming in to prove the tip is true. The tip is coming in to show what law enforcement should have done with that tip, which makes it not hearsay. Just because the same testimony, if offered for its truth, would be inadmissible hearsay, does not mean it must be excluded. Again, like a tip. In fact, various cases recognize instances where testimony may be offered for the purposes of Bowdoin defense, but not for a third-party culprit defense. By definition, questions about Buchanan's investigative knowledge are not hearsay. The testimony elicited from these questions go to his knowledge, understanding of the investigation as it was unfolding, not its inherent truth. And that's been a big deal with Buchanan because he hasn't known a lot. And if I'm the defense, I'm going to say the supervisor to the lead investigator knows nothing. How could he have possibly investigated this case properly? There's no way. He did not even have the knowledge. Truth be told, still going in June, still going to trial in June. Where? Oh, me. I thought you were talking about, will Karen Reed's trial still be going? Yes, but unfortunately, the other side filed a late motion to continue today that we are fighting and objecting to and trying to stop. It's in Pinellas County. Jury wanting to stay during Higgins' question speaks volumes. Maybe, or they just maybe the jury doesn't want to leave every day at 4, right? Just because that's how the judge runs the courtroom doesn't mean that's what the jury wants necessarily. The Commonwealth's motion recognizes that questions about an investigator's knowledge under Bowdoin defense are not hearsay. However, it proceeds to suggest that answers to questions to this effect are inadmissible hearsay. The Commonwealth's motion goes to accuse the defense of asking repeated, improper, and argumentative questions, and yet does not offer one example of such questions. That's what I was waiting for. What question? They talk about some of the Yuri Buchanan stuff. The big problematic thing they brought up about the federal investigation, that Yuri Buchanan was not subject to that, like it was confidential. He was outside the circle of trust. He did not know a lot of that. I agree with that. And I don't think the defense should be able to ask those types of questions. But did they? And if they did, cite some. Cite the record. It's being live streamed. You can go back and pull the exact question on the exact day with a timestamp, even if there's no transcript yet. So why didn't we see any of those if there were so many of those problematic questions? Were the Commonwealth motion granted, it would effectually gut Ms. Reed's ability to offer a Bowdoin defense by erroneously classifying the very questions and testimony that compose a Bowdoin defense as hearsay. I agree. And that's why I think if it's granted in part, denied in part, it's basically she's going to take it on a case-by-case basis. The Commonwealth is correct that it must be reasonable to expect that the police should have followed certain procedures or investigated such information to be admissible. The Commonwealth fails, however, to explain what precisely is unreasonable about the defense raising alternative suspects that state police chose not to investigate, despite being aware of their potential motives and opportunities to commit the crime Ms. Reed is accused of. The Commonwealth states that the defense's questions thus far have been improper and yet provides not one example of such improper testimony. It is true, evidence offered for a Bowdoin defense must be relevant and more probative than unduly prejudicial. Here, the Commonwealth makes the bare suggestion that testimony about Buchanan's knowledge of other potential suspects is irrelevant. However, it is unclear how a key investigator's understanding of the investigation could be anything other than relevant. What does he know? What did he do? What does he understand? What does he take that to mean? Who did he talk to after he found that out? What did they say? Did it lead you to do anything else? Did they confirm what somebody else said that you decided not to investigate? All that could be hearsay outside of a Bowdoin defense. Further, it is worth noting that all the evidence or testimony proffered by one party will be prejudicial to the other. Duh. The key question is whether the testimony in question is unfairly prejudicial. If the evidence is relevant to the adequacy of the police investigation, the judge must then determine whether the probative value of the Bowdoin evidence is substantially outweighed by the danger of unfair prejudice. Does the January timestamp on the Higgins video auto adjust for the time change, or could the actual time be 1 hour earlier since the time change in November? I don't know. That's a technical question that I don't know how it works with that video. Doug, what do you think? Is Morrissey just playing the long game? He knows Higgins McAlberts did it, but he can't actually go after them until the not guilty verdict. Example, he has his best to protect them. No, that is not the way you get a conviction, because let's say they went after Higgins or any McCabe or Albert, they would point the finger at Karen Reed, and I would probably be sitting here telling you that is reasonable doubt. That is reasonable doubt. Katie, Peter, how can she rule on this when the Commonwealth hasn't told a theory yet? I don't know what you mean by, you mean like they're accident reconstructionists? She could still rule on this. The rule should be no. The rule should be you lose, Commonwealth. I've already this is basically don't let them do a Bowdoin defense, which they've already filed that motion and lost. Peter, do you just love all the lawyers and chess playing going on? I do love it. I love the strategy of it. Then I love to see the strategy being put into play. Anybody can sit back and be like, oh, you know what you should do? You should shred Yuri Buchanan. You should put this person on. It's like, yeah, sure, it's easy to say, but can you actually put it into practice? Can you actually implement it? It's kind of like a coach having a really good playbook. Great. But can you work on it? Can you coach the players up? Can you teach them how to do it? And can you go do it on the field? That's the question. Wouldn't John be wearing a coat? Those plastic pieces would have to be shot into John. We know what he was wearing. And the Commonwealth says there were shards there. The defense says maybe they were planted. Maybe they were mixed up in the bag. Maybe there are other explanations for it. But we're yet to hear that in this trial yet. Catherine, if the investigation shows bias and the judge is biased, can anyone put a stop to it? Yes, the jury. The jury. Peter, can we watch your genius in any trials that you have been involved in, or are these not televised used? None of them have been streamed at all that I know They've been streamed to CCTV inside the state attorney's office where we could watch each other's trials when I was there, but none of them have been live streamed. I don't foresee a lot of them really being live streamed. There's some potential for some, but a lot of mine deal with injuries and wrongful death and a lot of medical things that most people would rather not be live streamed. I would never push them to be live streamed for my client. If it happens where it does happen, I'm sure you guys will know about it. Linda, Peter, you said that the motion covers 90% of what AJ asked YB. How do you think Bev will rule, denied or granted? No, I don't think I said the motion covers 90%. I'm saying I think 90% of what they're asking is completely appropriate. Maybe that 10% range is objectionable. Part of that 10% range might be appropriate for that motion. And because it's such a small percentage, that's why I think Cannoni should just do it on a question-by-question basis. Madison, was the footage of Higgins on the phone the same as his call to Brian Albert? No, I don't think that was the same timestamp. Sarah Sally, how great would it be for the defense to call Proctor and he takes a page out of Michael Cohen's book and flips on everyone his mea culpa? I don't think that's going to happen. I could be wrong, but I don't think that's going to happen. Sheila, my son is 25 and he dresses like you. Where do you shop for the button-down short sleeve sweaters? I find them difficult to find. I have two things to tell you here. Number one, we are getting some of those on the Lawyer You Know site. We're going to do a new merch line and merch drop coming up for the summer. And those kind of short sleeve button down, looser fitting sweater and other types of shirts are going to be on there. Number one. Number two, Quince, the sponsor with the code LYK. It's going to be on this Monday's podcast. So awesome stuff on there. I've been getting a bunch of stuff on there on that website. So check that out. And then my wife gets them like from random stores, like I think like from Abercrombie, she got one or something. But yeah, so the ones my wife gets, I don't know, but wait till the ones come on the website. That'll be cool for our merch site. Taurus, what are your thoughts on his Jeep and when did he actually leave Fairview? Well, I don't know when he actually left Fairview, but it's probably a good indication it was around 1:30 or I guess 1:30 if Canton PD was only a couple minutes away and he gets there at like 1:35. So I think that's reasonable. There's so much suspect about him and what he was doing and why he was doing it that the defense needs to continue to highlight that. Idiot Wind. Doesn't making the right decision begrudgingly, despite knowing it's the right decision, betray some bias, especially with how that translates in leaning and rulings that fall into the scope of her wide discretion and how she acts in court? Yes, I would tend to agree with that. And when she's granting a defense's motion or denying a Commonwealth's motion and has negative comments that are really of no legal value toward the defense team, that shows a bit of bias to me and is problematic. Portia, Peter, in my opinion, tunnel vision was used by law enforcement. What do you think? I agree. And that's the type of stuff I would use. Tunnel vision, when they thought it was her, they wanted to make sure it was her. Even right now, they may believe she's guilty. So they think, you know what? We're going to do what it takes to get that guilty person. And that still is inappropriate. Even if law enforcement truly believes somebody's guilty, they still have to play by the rules. Madison Phillips, do you think Jackson being so in your face and aggressive has a negative impact on the jury? It would for me as a juror. So Madison, I appreciate you bringing this up. And I've said this a million times. I think he is the type of personality that some jurors would absolutely love and just take his hand and follow him wherever he wants to lead. And there's some that probably don't like it. I worry about that sometimes with my natural personality and demeanor. So I try to tone it down at times and kind of pick my places to really go hard when I'm in trial. Most of mine are civil as well. So it's a little bit of a different vibe. But yeah, I get it. I get it. And I do think that's a possibility. All right, let's get back to this motion. Is it true the evidence, it is true the evidence offered for a Bowden defense must be relevant. Already read this. Here, it is unclear how such testimony would be unfairly prejudicial to the Commonwealth, particularly where the Commonwealth has the opportunity to rebut any testimony on redirect, and they did. The appropriate avenue for the Commonwealth's concerns is a robust rebuttal. How about them taking a page out of Cannoni's book? Further, the Commonwealth asserts no basis in its motion for the claim that voir dire is the appropriate way to address their unsupported claims. The Commonwealth cites Avila to suggest that the defense is seeking to elicit what it calls inadmissible hearsay and to support its request for a voir dire hearing. However, that case did not address voir dire issues. Rather, it allows for a robust rebuttal by the Commonwealth of a Bowden defense via redirect and the introduction of additional evidence. Further, Avila holds that a curative instruction about the purpose of testimony offered for a Bowden defense and in rebuttal was an appropriate avenue to address concerns as to the testimony that would be considered by the jury. So I kind of think after reading this case and reading this argument by the defense, this might be what Judge Cannoni said at sidebar. Listen, Brennan, I'm going to give you leeway, a robust redirect where he basically repeated everything he did on direct with Buchanan. He went through the entire investigation again. He went through their entire theory. He went through how all the evidence as they see it points to Karen Reed and Karen Reed alone, and X, Y, and Z reasons why it couldn't have been Brian Higgins. And they did look into it enough. And there was no reason for them to think it was Brian Higgins any more than had already been discovered or discussed, I should say. Let me see. Effective cross-examination is a critical safeguard of liberty and an invaluable tool for testing the reliability of evidence. A+ has to be there, the most important thing for criminal defense attorneys. And as the Supreme Judicial Court has long recognized, surprise is an important element of effective cross-examination. Here, the Commonwealth seeks to undermine this important right and vitiate Ms. Reed's constitutional right to cross-examination a key prosecution witness by seeking an order that Sergeant Buchanan be permitted to preview the questions that will be asked by the defense at a voir dire hearing in advance of his testimony before the jury. This request must be denied. Ms. Reed has the right to mount a vigorous defense of the allegations against her. She has a right to confront and cross-examine witnesses, and she may present evidence that police investigation in this case was deficient. Ms. Reed respectfully requests that the court deny the Commonwealth's request to deny her constitutional right to confrontation. So, after seeing what we've seen, the judge allowed the voir dire on the Albert Proctor connection, but not on all the questions the defense planned to ask Yuri Buchanan. So I think she denied a lot of that motion, but probably told the defense, don't do X, Y, and Z. Don't ask about the federal investigation of some sort, if I was going to have to guess. But I don't think this is the end of this discussion if there are more law enforcement witnesses to come. Hurtando, do you think Lally is pissed Brennan took over? He's probably like embarrassed or feeling like bad, like a shot to his confidence. But also it's like a lot easier to sit there and get paid the same amount than to have to do all the work, right? Does the AJ always know who will testify each day? It seems like they are sharing that with each other. Most judges force lawyers to do that. I always appreciate that. I always do that as the plaintiff's lawyer. Here are the 4 people we plan to call tomorrow. So everybody's on the same page. Everybody can be prepared. HB promised a fair trial and all facts would be fully aired. Why is he now hiding MP? Is he really interested in truth and justice winning over the truth? I don't know that he ever said all facts would be fully aired, but I get what you're saying about the fair trial. KM, how many hours do they need per week to put in? Surely over 12-hour days. Do they tire out? What is your experience during trials? It's incredibly tiring. It's brutal. Easily 12-hour days. You basically take a break. I take a break to work out and eat. And if I can't, so sometimes I'll go stay in a hotel for a trial. If I'm staying at home, I got to spend some time with my kids as well because I just have to, and I can't be around them without hanging out with them for an hour or 2 here and there. But usually, I'm working until right before I go to bed, and I'll try to do something to settle my mind down, either listen to something, watch something, read something, whatever it may be. And then in the morning, I try to read something not case related to get my brain going. But basically, eating and working out is most of what I do. If it's so, the rest of the time I'm up, I'm basically working on the trial. My guess is they're doing the same. J-Bone, longtime watcher, first time super chatter. Isn't Higgins an ATF agent? Yes. Why would an ATF agent be roaming a police station? So his office is in Canton PD. So theoretically, he could say, I just went to grab something from my office late that night after drinking a ton. Doesn't seem like the best idea, but in the last live, you mentioned a possible Brady violation. Was that not the video Proctor buried? Can she be acquitted like in the Baldwin case? So no, because they got it before this trial. But theoretically, I think it would have been a discussion had the first trial ended in conviction. So because all of that was cured before trial number 2, it's a different story. How do I join? I'm so confused. Kelsey, will you write in the chat how to join as a member? Sometimes you can't do it on your phone, people have said. I'm sure there are some other people in the chat that can explain it as well. I'm curious if there was any bug life on his lacerations, if killed inside versus outside snow fleas. I watch too much ID and forensic files. Where is John? Thank you for these daily. He had a meeting. I think he actually just walked in. I heard the door open back there. So yeah, and you know what, Netwoman, that's funny is we talk to jurors and jury selection. So many of them watch so many different shows that we want to know because they might have questions like this. And if anybody on the defense team or prosecution team is watching this and they hear you have these types of questions, there may be somebody with similar interests that if they feel like this evidence will help them, maybe they'll dig into it. Peter, you should get something that says, I'll allow it on it with your new merch. I told John my favorite quote to come from this trial is I already know the questions to my own answers. I do love that. Madison, my son is 16 and wants to be an attorney. We love your channel and your expertise. God bless you and your family. Well, Madison, tell him to keep his head down, work hard, have fun, make good relationships. Build relationships starting now at 16 years old. Sad reality, when Karen Read is found not guilty, the real killers will remain free. V Slims, Peter, I understand Karen wasn't feeling well and wasn't going to appear today. Is that why court was canceled? And will the judge excuse her absence? Yes, that's why we hear the reports are that's why court was canceled. And yes, the judge is not going to reprimand her or anything like that for this. Haley, can you quickly explain credibility versus reliability regarding legal definitions? So evidence is not necessarily reliable. There's definitely some crossover between credibility and reliability. No doubt about that. I would consider them very similar. But a lot of times reliability is used when a hearsay statement is not reliable because this person told that person who told that person. This evidence might not be reliable or even credible because the chain of custody was broken. Credibility a lot of times goes to a person or a witness. Are they credible? Are they biased? Are they forgetting a lot? Do they seem like they're lying? Are they getting impeached a lot? Crushing that witness's credibility. That's usually legally how it's used, but I would not have a problem with a lot of people using them interchangeably. Bill, forgive if asked, are they going to show video of the Lexus backing into a car to explain taillight or tire spinning on Lexus when loading on a flatbed to explain 20-mile-an-hour speed memory? I don't know. I don't know what they're going to show. And that's why the accident reconstructionists, to me, are always going to be the most important and biggest witnesses in this trial. We haven't seen either of them yet. We saw from the Commonwealth last time, and even without the defenses, it was horrible. So we'll see if the Commonwealths are better. We'll see if the defenses are better now that they've already been prepared actually by the defense versus last time just showing up and testifying. All right, we have one more motion we're going to read here. Let me pull it up. This one I was a little surprised at. So we know during cross-examination of Yuri Buchanan with the text messages of Brian Higgins and Karen Read, they got into, Buchanan thought it was revenge, and Jackson was like revenge for New Year's Eve. And that was the whole Aruba incident that came in last trial that I thought was kind of weird. And to me, it was pretty confirming that the jury was not guilty on second degree, because that means they didn't feel like that Aruba stuff mattered at all to me. Or at least not for the appropriate legal reason. And now it seems like Hank Brennan wants to get into that Aruba evidence, even though pre-trial he said, we're not going to get into it. He feels like Jackson has opened the door and he needs to get into it to tell the whole story. The Commonwealth moves to admit testimony through percipient witnesses who observed the defendant and victim's volatile and hostile relationship as it existed at the time of the victim's death. And then he goes into 4 weeks prior. The defendant became enraged at the victim for speaking to a female friend who was on their group vacation in Aruba and accused the victim of having an affair. So again, that's definitely the Commonwealth's characterization of how they think the evidence is going to be presented and what they think the true evidence is. I think the defense would have a different theory as to what happened and why it happened. Regardless, this goes to show motive of why Karen Read would want to hurt or end John O'Keefe's life, which mostly would go to second degree, not some kind of accidental or maybe even manslaughter, but not any kind of negligent homicide or accident, right? Which again, we go to the voicemails and just so many things happen that would make you think. I just don't feel like there's any way Karen Read knew she hit John O'Keefe or intended to hit John O'Keefe. Even if you believe it, most of you have said you think it was an accident, that she hit him because she was drunk and didn't know. And then, don't necessarily believe that there was a really, that there was real intent there. So CAA said, HB's words, facts will be fully and fairly aired. If that's what he said, then you're right. He's leaving out a lot of facts. He's leaving out a lot of facts by leaving out Proctor. You may be absolutely right about that, and that's a very good point. Very good point. Okay. This incident was observed by numerous individuals who will testify to their personal observations of the incident, as well as to statements of the defendant in the immediate aftermath. Evidence of the defendant's prior bad acts may be admissible to prove opportunity, intent, preparation, plan, knowledge, pattern of operation, or common scheme or course of conduct, as long as the probative value of the evidence is not outweighed by the risk of unfair prejudice. The determination to admit such evidence based on the timeliness, place, character, or probative value is one for the trial judge to make and will be reversed on review if only if palpably wrong. Okay, so what is the unfair prejudice here? Why would the defense object? Well, the unfair prejudice is, once again, them using the generally bad gal rule against Karen Reed and trying to get the jury to hate Karen Reed, dislike her as a person, think she's disgusting, foul-mouthed, jealous, jerk who would do something like this to her boyfriend. That's character evidence. That's character assassination. That would be one of the reasons I would object to this, because I don't think it's all that probative. I don't think it's all that bad for the defense. But if the jury's starting to get sick of hearing Karen Reed swear at John O'Keefe, talk to other guys, be mean as they might see it through text messages, through voicemails, and then you add this on top, maybe there will be some jurors that are like, I just don't like her. And I think that she maybe did something wrong, which does not prove a crime beyond a reasonable doubt, but that's not an appropriate use for this evidence. That's what the defense would likely object to and why they'd want to keep this out. Evidence of the Aruba incident was proffered by the defendant through a series of text messages between the defendant and Brian Higgins, thus opening the door for the Commonwealth to rebut the defendant's misleading and inaccurate claims about what had occurred weeks prior in Aruba. This incident in Aruba seems to also be the turning point in the relationship, as the defendant told Brian Higgins that her relationship with the victim was a very effed up situation, as she had observed the victim all over a friend's sister in the lobby of our hotel and accused the defendant of having hooked up with another girl while in Aruba. So here's the other thing of why I would think that this is not actually correct is that's exactly what they're going to elicit anyways, is that Karen Reed thought that happened. Now, to call the one witness to say that didn't happen, fine. But what else Karen Reed said about it, I think would be cumulative, and the jury has already heard it. So if you really want to impeach Karen Reed and say that's not what happened, call the witness that'll say, no, I didn't kiss him. It was a hug like a brother or whatever she said. Victoria asks, hey, Peter, do you think the jurors are keeping the defense's opening in mind while AJ is crossing the cops? I would. I hope they do. Hard for me to know what they're actually thinking, right? But I hope they do. Vicky Ruiz, learning the R word was used by Proctor disgusts me. Who will watch the guards? Juvenile. Worried that they are in charge of the rights of disabled people. Yeah, I mean, and that's the point is, while there are some things they're saying that might make them hate Karen Reed, there are definitely things they're saying that'll make them hate Proctor and maybe some other cops as well. Joanne Roberts, Peter, sidebar, are you going to talk about Diddy today? I haven't had any questions about it. So if people ask questions, I'm more than happy to do a Diddy recap and talk about it. I know Cassie is testifying today. I'd be more than happy to talk about it. I just haven't really gotten any questions on it. Kathy, do you think Auntie Bev resents having an LA lawyer in her courtroom? I don't know. Maybe. Some judges don't like out-of-towners, regardless of where they're from. All right. Evidence of the Aruba incident was, okay, wait, I already read that. Opening the door. Maybe not. Evidence of the Aruba incident was proffered by the defendant through a series of text messages between Brian Higgins, opening the door. Oh, no, I did read this. The January 29th voicemails previously entered into evidence. The defendant screams at the victim for apparently effing another girl, repeatedly refers to a victim as a pervert. There also has been evidence that prior to arriving to 34 Fairview, there was a reference to a woman and the victim used to date. The defendant proffered the entirety of the text messages between herself and Brian Higgins, including the defendant's admissions about her feelings toward the victim and the nature of their relationship. Right, it's already in. The evidence proffered by the defendant also demonstrated a continuing animosity in the weeks and days prior to the victim's death. And all that's already in. The jury should be permitted to hear from the witnesses of this Aruba incident who will rebut the characterizations made by the defendant to Brian Higgins. Such testimony would be offered through Laura Sullivan, Marietta Sullivan, Aaron O'Keefe, that would be interesting, and Juvenile KF. Evidence of a hostile relationship that tends to explain the purpose of a crime is relevant to the issue of malice or intent. So that's what he wants to get into, malice or intent. And so there's some annoying things about this because he said he wasn't going to use it. So the defense hasn't prepared anything in their opening statement or anything that they've done in cross already of all these witnesses about the Aruba incident. So that's one thing that's frustrating. And now he's changing course. He didn't actually, I can't say that. I don't know. Did Hank Brennan say if they open the door, we might get into it? If he did, totally fair game. Either way, the judge is definitely going to consider this. I would expect the defense to object. They had an argument ready to argue in a pretrial motion that Brennan was like, I'm not going to say it. So they didn't even argue it. So my guess is they're prepped on this issue. By the way, we're over an hour. We're almost done. We're definitely not going that much overtime today. So hit that like button if you guys have not already. Will the jury know about Birchmore or his knowledge of that case weeded out in jury selection? Thanks for all you do. So that's a good question. I don't know if they talked about it in jury selection, but it is not coming in this trial. The judge is not allowing them, unless the door is opened, to get into any combinations of parallels between this investigation and the Birchmore investigation. Okay. In a domestic violence homicide, evidence such as prior disputes are relevant to show the volatile nature of the relationship between the defendant and the victim in the weeks and months preceding the crime, and to explain the defendant's intent and state of mind toward the victim. Evidence of domestic dispute at defendant's apartment before the killing, including physical contact, was relevant to show volatile nature of the defendant's relationship with the victim and defendant's intent. Evidence of the defendant's prior arrest for assault and battery of a victim, defendant and victim's restraining orders against each other, and pending divorce proceeding admissible in homicide prosecution to show motive and hostile relationship. Evidence of defendant's previous threat to stab his girlfriend admissible to show parties' violent relationship. Allowing previous domestic incident by defendant against the victim be admitted in prosecution for subsequent domestic violence to show nature of relationship between the two and to show intent, motive, and absence of mistake or accident. So all of these examples, as you'll see, are much more significant than what they're trying to get into in this case. Evidence of domestic violence committed by the defendant against his girlfriend, which led to confrontation between the defendant and the victim, properly admitted to show contentious nature of the relationship between defendant and victim, which provided motive for the death. Evidence that the defendant formed an attachment for another may form bias of an interference that the defendant entertained feeling of hostility towards spouse prior to killing. Moreover, in the state of mind exception to hearsay, the rule calls for evidence of a victim's state of mind as proof of the defendant's motive to kill the victim when there also is evidence that the defendant was aware of the state of mind at the time of the crime and would likely respond to it. Peter, have you noticed how quietly Brennan objects? He says object and not objection. It's like he's ashamed of the case or lack thereof. I'm not positive, but I think it's just because he's away from the mic. That would be my guess. Bill, have you heard the interview of ex-cop that says that he knew car body man that removed the taillight? Could that be where Lexus was when it was missing from the Sallyport? Potentially. Or the mechanic could have come to the Sallyport. Yes, I've heard at least one interview with that cop, and we did a breakdown on the channel as well. I wonder how Jen McCabe, who has MS, feels about Proctor mocking medical disabilities. As someone with IBS, I'd be ending that friendship so fast. You want my guess? It probably doesn't bother her with how she feels about Karen Reed. That'd be my guess, but I don't know. It's pure speculation. Evidence of the defendant's prior conduct is permissible and highly probative to show the defendant's state of mind, to show the defendant's motive, to show the defendant's common pattern of behavior toward the victim, in particular as demonstrated by previously admitted evidence that the defendant would become enraged and accuse the victim of cheating on her, and the nature of the defendant and victim's relationship. Massachusetts courts have repeatedly admitted evidence of prior bad acts to demonstrate a hostile relationship between the defendant and the victim because this hostility is relevant to the defendant's motive to harm or kill the victim. A victim's intent to end a romantic relationship is material to the defendant's motive for hurting the victim. That's already in. We already know that. Hank Brennan's already making that argument. The admission of such evidence for the purposes of illuminating a pattern or course of conduct by the defendant is proper. I just don't get how Aruba proves that John O'Keefe was trying to end the relationship. When they say nothing happened, it's just to show jealousy of Karen Reed and motive as to why she would want to end his life. It's not a lot of these other things he's citing, in my opinion. The Commonwealth is entitled to present a full picture as possible, as full a picture as possible of the events surrounding the incident. Where the defendant has opened the door, it is especially significant for the jury to understand that it was the defendant who repeatedly refused to accept the victim's desire to terminate the relationship. The defendant made repeated hostile accusations that the victim was having an affair and that their was an established pattern of hostility occurring in the weeks and days preceding the crime. For all of the above reasons, prior misconduct and evidence of domestic violence should be admissible at trial. Well, I don't see the connection to some of the things Hank Brennan is saying, and I think that he's kind of conflating some of this. I do tend to agree with him. I do tend to say the defense opened that door, and I would understand if Judge Cannone allowed the Aruba evidence in. Frankly, even without the defense opening the door, I could see the argument if the Commonwealth wants to try and use that as motive. I think they're dead wrong. I think it just kind of makes it look like they're reaching. I said I thought it was a smart strategic move for Hank Brennan not to go down the Aruba path. When he decided not to, I was like, I think that's actually a smart move. But now he's changing course, which brings me to my last point. By the way, I think Judge Cannone will allow the Aruba evidence. But it brings me to my last point, which is how else will Hank Brennan change course? What the defense is doing, is it causing Hank Brennan to think twice about some of the strategy he had going into this? And will that include calling certain officers, former officers, or witnesses that maybe he wasn't planning on calling? That's a big question I have to see what happens as we continue going through this trial. Josie Mojo, learning from you, trying to see the testimony as a first-time juror. It seems to be going better for the defense at this stage. More cohesive story and rebutting the Commonwealth's evidence. What do you think? So there have been parts of this trial that I have felt have been better for the Commonwealth, parts that have been better for the defense. Overall, I still see a humongous gaping hole or multiple holes of reasonable doubt. The real question is, will the accident reconstructions for the Commonwealth be so much better than Trooper Paul that it gives them a better shot this time around? Christopher, did ARCA meet the deadline? I assume we haven't had any other motions to try and strike them. I'm not positive, but I assume they did meet it. If not, we'll find out. Anna, you said the Higgins video was significant. How do you think the Commonwealth will address it? Seems like they kind of already addressed it with Buchanan saying Higgins was not a suspect, never a suspect. We didn't think he did it. All the evidence pointing toward Karen Reed. We never even really considered him as a real suspect. He gave us his phone. He cooperated. He talked to us with his lawyer, which I don't have a problem with. So I think they've kind of already addressed it. Unless they call Higgins, that'd be the only other thing. Brennan is going down the Lally path of trying to prove the defense wrong. Yeah, well, I mean, you have to eliminate the reasonable doubts, right? You do have to do that, so I understand. But you got to be careful. Don't overtry the case. Don't overcomplicate it. All right. That's all we got here. So hit that like button if you guys haven't already. King Pine Worldwide. Sorry, I'm late, Peter. Do you think you'll start using dialed in your daily vocabulary after one range session, flushing your clubbies? Go Knowles. Go Gray. Albright. No, I don't. I don't think I will, but we'll see. Who knows? Only time will tell, right? All right. So that's all we got. Appreciate you guys hanging out with me, even with no court. We'll be back at it hopefully tomorrow. Hopefully Karen Reed or whoever is sick is feeling better. And we are back to court tomorrow, continuing to move this case along because for the jury's sake, if nobody else, right? For Karen Reed, for the witnesses, for everybody involved, for the O'Keefes, and the jury. We don't want to delay this any more than possible. We don't want to give any opportunity for them to maybe see something on social media that may affect them either way. So hopefully this case continues going down the road. I appreciate you guys all being here. Till next time, hit that subscribe, and I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.